The next topic that we have is Family Education Right to Privacy Act, FERPA. How many of y'all have heard of FERPA? Good. We have with us Chris Gilbert, a Houston attorney with experience in advising educators on FERPA, and he has come all the way from Houston. When I was putting this program together and I was asking for different people who were experts in the area, I was told I needed to reach out to Chris. So I think that makes you an expert. So thank you for coming, and I'll turn the floor over to him.
Good afternoon. All right, I'm going to try to leave my crutch there and do this without that. I injured my knee twice in the last 2 weeks. It's not nearly as bad as it looks, but I do think my football career is probably over. All right, so we're going to talk about FERPA. FERPA is the document privacy law. This is the law that basically says it prohibits school districts from releasing personally identifiable information about students from their education records. Now, that sounds like a really good idea and a really logical idea, and in a lot of ways it is. The problem is FERPA is the great law of unintended consequences, because we are constantly coming up with situations where we wonder, can we release this information? And it seems like the law is stopping us from doing it in a situation where it would help. That comes up a lot in student discipline situations, and we'll talk a little bit about that. But I'll give you an example. You know, if you are a coach and you're a baseball coach, and after the game, you call up the local paper to tell the paper, you know, who hit the home runs and what the pitching record was and what the batting records was of all the people, you may have just violated FERPA. Now that's true, despite the fact that that's a positive thing, that nobody would really probably complain about that information being released, but it does come from student records. It's also true, even though it's information based on a baseball game that was publicly available that everybody could go to if they bought a ticket or maybe even for free, and could see all of the actions of the players that led to those records. And I actually had a long-running dispute with the Family Policy Council office in Washington, D.C. over whether a school district that released this information violated FERPA. And they believe that the school district did, although we ended up working it out. So there are a lot of times when you say to yourself, but it really would make sense if we could release this information, and this law seems to stop us from doing it. So we're going to run through it. It has not been changed much in recent years. It's applicable to all programs funded by the U.S. Department of Education. And again, it prohibits what we call personally identifiable information. So throughout this outline, if you see PII, that's personally identifiable information, without consent from student records unless an exception applies. And there are a lot of exceptions. We're going to talk about those. The other two things that it does, this is sort of the lesser known aspect. Everybody knows that FERPA stops us from releasing student records. It actually does two other things. It guarantees parents and students a right of access to their records, and there's a process that they can go through for that. It also allows them to file a complaint seeking to change their records. Now, that's not a complaint process by which they get to argue about the underlying incident. If they went to the DAEP and they're still arguing, I didn't do it, and they want to file, you know, and that your record says they went to the DAEP and they want to file something, that's not what's meant. What's meant is if they got an A and the transcript says they got a B, they can file a complaint and say that's just wrong, and that's what the process it is. But there is a process to actually amend records under FERPA. So an education record is any record that directly relates to a student that's maintained by the school district. So the word education is actually meaningless in this definition. It's sometimes people think, oh, it must be something that's about their grades. It's not. It's basically any record about a student that's maintained by a school district. So it's a very broad definition, and it includes anything. It includes not just physical records. It includes all data about the student. So anything in our computers or anything that we maintain on social media or something like that. All of that would potentially be subject to FERPA. Personally identifiable information that we're not allowed to release, it's a fairly long list. It includes the student's name, their family members, the parents, you know, addresses, Identifiers like social security numbers or potentially student numbers, biometric records if you happen to have those. Indirect identifiers like their date of birth or their place of birth or their mother's maiden name. All of those could be subject to FERPA because those can be used to identify a student. Basically, it applies to any information that alone or in combination with other information could be used to identify the student. So sometimes when we're asked for information, and these requests frequently come in under the Public Information Act, sometimes we actually have to sit down and say, okay, if we release this information, is somebody going to be able to put two and two together and figure out who the student is? So, you know, if you're a school that has a very low minority rate, let's just say you have a very small number of African-American students, somebody wants to know, you know, what the grades are for African-American students in certain classes, you may not be able to release that information because if there's only one African-American student in that class, they're going to know whose grades those are. So sometimes you have to kind of put two and two together to decide, is this something we can or can't release? When we're talking, and FERPA has been coming up a lot recently as we do more and more with online service providers, particularly during the pandemic when we were doing remote education, but obviously we're doing a lot more of that as we go forward. This is something we need to think about when we're setting up our online system. Because again, if we use identifying information to allow students to log in, and we provide information to those service providers that would allow them to identify those students, that may be subject to FERPA. And I'm going to talk a minute about that because there is a way around that. So, you know, if you require them to put their social, and probably nobody uses social security numbers, but if you did and you required a student to put their social security number in, that might violate FERPA. If you can log in using a meaningless password, that might not. So those are things we need to take into consideration when we're looking at this. Now, online service providers collect a lot of metadata, and we all know about that. You hear a lot about that, and people are concerned about that. Metadata, generally speaking, is probably not going to be personally identifiable information. So metadata, for example, might be how long it took a student to finish a given task or a given assignment. Probably that information is not going to allow somebody by itself to identify who that student was. Maybe, but probably not. So metadata, even though that's a concern in other ways, probably isn't going to constitute personally identifiable information. So generally speaking, we as a school district cannot release personally identifiable information unless we have first obtained the written consent of the parent or the students. So that's one question that always comes up is, if for some reason we need to release information, have we talked to the family? Have we asked them if we can't? Because if they allow you to do it, it's not a violation of FERPA. And we want to get that consent in writing, and you want to document that and put that in the students' files. So one question that comes up a lot is verbal communications. If I tell somebody something about a student, does that violate the FERPA? Does that violate FERPA? And the answer is, it depends. FERPA is a document protection, document privacy law. It's not a general privacy law. And some people don't realize that. It doesn't apply to everything you might know, but it does apply to what you learned about a student from their educational records. So I'll give you an example. If a reporter calls the high school and says, and they get the assistant principal and they say, hey, I understand there was a fight at school today. Can you tell me something about it? And the assistant principal says, oh yeah, it was between Bobby and Jimmy and they got in a fight and blah, blah, blah. Does that violate FERPA? If it's from the assistant principal's personal knowledge, if they were there and witnessed it, or if they even heard about it from other people, the answer is no. That might violate privacy rights otherwise, but it doesn't violate FERPA because it's not information that came from an education record. But if they call the principal and the principal wasn't there for the fight and all he did was read the discipline reports that came in, that would violate FERPA because that information came from an education record. So you could literally have two different people giving a reporter the exact same information. One situation would violate FERPA because it came from the education records. One situation would at least technically not because it came from their personal knowledge. So again, that's what makes FERPA kind of an odd law. There are situations where we might even be able to release more information. Again, whether we want to or not, that's a different question. But at least legally, we might be able to release more information than we think simply because it comes from our personal knowledge as a school official. So what is not an education record? Well, there are some things that aren't education records. This first, you're going to think this first one's kind of silly. Grades on peer graded papers before they are collected and recorded by a teacher does not violate FERPA. Why do we know that? Because somebody sued over that, and that case went to the United States Supreme Court. That's Owasso Independent School District versus Salvo. This is literally the old kindergarten situation where a kindergarten teacher, maybe a first grade teacher, but it was an elementary school, gave a quiz and they said, you know, they read out the answers and then they said, okay, pass your paper, one over, one back, or whatever it was. Now we're going to grade it. And then she took it up. Somebody sued over that and went all the way to the United States Supreme Court. That must have been a really bad grade that child got on that exam. The court ruled that it did not because, and only because, the teacher hadn't touched the test yet. She told the kids to pass them one back or one over or whatever it was. So because the teacher had not picked up the grades yet, because they hadn't been collected and she hadn't reported the grades, it technically wasn't an educational record yet. Had the teacher picked up the tests and then kind of shuffled them and then randomly passed them out, that would have violated FERPA under this logic. This is why this is the great law of unintended consequences and why sometimes it's just really hard to see how this law is going to apply or how it's not. One of the main things that you as a school person may have that may not be education records are what we call sole possession notes. Now, sole possession notes are really just that. These are notes that you take as sort of memory joggers for your own use. These are not notes that we take like at the ARD meeting when we're doing the official notes of the ARD, or if you're taking notes during a disciplinary hearing and you're going to sort of like put these notes in the file for the student. This is truly when you as a teacher take notes about students and you just use them to remind yourself about various things. So they really can't be accessible to anybody else except maybe a substitute when the substitute is using them kind of for the same reason that you would be as a teacher. So it's intended to be a limited category, but there are times when your personal notes would not be considered an education record for purposes of FERPA. Again, these are notes that you haven't revealed to anybody, very narrow. It does not include emails because when you write an email, you're writing it to someone else. Now, I suppose if you wrote an email and sent it to yourself, and we've probably all done that at one point or another, just to write something down, that could be a sole possession note. But generally speaking, emails are not going to be sole possession. And again, it's not intended to exclude from the student's educational records that are really sort of about that student. It's really more your thoughts about that student, if that makes sense. So again, if you have prior written consent, you can release these records. So I can tell you that a lot of the school districts in the Houston area, after we had the big kerfuffle over the baseball statistic case, a lot of school districts started asking their athletes to fill out a form that allowed that in which the parents would sign for permission saying that you could release this information. I think a lot of athletic departments do that just generally anyway. So if you have a form that they have filled out and said, yes, you can release, certain information to the paper or whatever, then you have prior written consent and you can release that information without violating FERPA. Now, again, you want it to be in writing, you want it to be signed, and you want it to be reasonably specific. It doesn't have to foresee every possible situation, but it needs to be reasonably specific as to what kind of information they're saying you can release and what the purpose of that release will be. So like I said, other than prior written consent, there are several exceptions to FERPA. And these are 4 of the big ones. Some of them are extremely esoteric and don't come up very often. But the 4 big ones are directory information, information shared for pedagogical purposes. That's the school official exception. That's the next one. And then health or safety emergencies. So let's talk a little bit about these. So directory information is information that is in the education records of a student that, if released, would generally not be considered harmful. So there is certain information that is considered directory information. It includes things like the student's name, their address, their telephone listing, their email address, photographs, data in place of birth, and then you can see some of the other grade level. All of those are generally considered directory information, which can be released, with a big exception that I'll mention in a minute. Directory information does not include social security numbers or student ID numbers unless it really can't be used to do anything. If there's no way for somebody to take a student ID number, if y'all are just making up sort of, random fake numbers, and there's no way for anybody to take that and use that to gain access to education records, then it would, you might be able to consider that directory information. To be considered directory information, the district must clearly define what we consider to be directory information and publish those elements in a form that we give to parents. So most school districts either have a standalone FERPA notification document, or it's part of your code of student conduct, and it says this is what the directory information is, and you list the specific categories. There are other things, if you want, that you can add for directory information. So that was actually FEPCO's original suggestion to my baseball thing, was you can add sports scores, because that's not going to be something that would generally be considered harmful to release. Put that in, make that directory information, and you can go with that. So again, the caveats are only information that we have previously identified and defined as directory information can be released under this exception, and parents and eligible students must be given the opportunity to opt out of this exception. So again, that's why a lot of your FERPA forms, they actually have they ask the parent to sign off, and they ask the parent, and different districts have done different things. There's no really right way to do it. Some of it's just a matter of convenience. But for example, you might basically make it all or nothing. So you might tell the parent, you can either say all of it's private or none of it's private. A lot of school districts have boxes where literally everything, name, address, email address, and you just go through and check off what you want. That's probably more in line with the intent of the statute. It is administratively really difficult to manage. We get a request for public information from the band instrument companies. How many people have dealt with the band instrument company PIA requests? They send them every year. So there are a number of band instrument companies that send address wanting the name and address of every kid who's in band so that they can send them something about buying instruments. And again, having to go through and look and see exactly who has checked yes, who has checked no is difficult, but that is what the law requires. Some districts have actually created sort of almost sort of a hybrid of that, where you can't pick and choose everything, but they have them sort of lumped into categories. So they have, and I'm trying to think right now, I worked with one school district, trying to remember how they phrased them, but they kind of had lumped categories of directory information, and you can pick and choose in those. So different school districts do it different ways. None of them are I mean, they're all permissible, and none of them are really perfect. They're all sort of hard to administer. So another FERPA exception is the school official exception. You can share information with school officials if the school official has a legitimate educational interest in knowing that information. Now, again, I think the word educational there is a little misleading, because just like with the definition of directory or student records in the first place, it means more than just pure education, pure academic type records. But you can share information, and this is the major way that we share information within a school district, within a school, without constantly violating FERPA. So you can share in that area. Now, a school official, again, is any employee who we have determined has a legitimate educational interest in knowing this personal information from the specific student's record. It can also include third parties. So it didn't used to, and that used to be a major issue when we were trying to contract with outside vendors for various things. And they changed the regulations in, I think 2007, to add in that if we define third-party contractors or consultants or volunteers or service providers with whom we have outsourced information for the purposes of providing services to us as a school district, that can count as a school official, and it's okay to share information with them. But if you do that with third parties, there are some rules you have to make sure you follow. And most of these probably won't surprise you all that much. We can do that. We can only do it if the third party is providing a service to us that we would otherwise do. So in other words, if somebody wants to sell Tupperware to students, we can't define Tupperware sellers as legitimate third parties and give them this information, because we as a school district don't sell Tupperware to our students. Most of us don't. So that you can't do. But if you want to, again, use a vendor to do online education, you could define that vendor as a third party school official for the purpose of outsourcing. That would be okay. We have to provide notice to the students. So again, in that FERPA notice, and this is the reason why that FERPA notice is really long and frequently has a very small print, we're supposed to define what we consider to be school officials. So if you are providing information, if you're outsourcing it, you want to define that in your notice. And then again, they can only use the information for the purpose that we are outsourcing it to them for. So they can't take it and run with it. And I think, so again, your annual notification should provide what the criteria are for who we consider to be a school official and what we consider to be a legitimate educational interest. So here's a hypothetical. Your district contracts with an online platform to provide virtual learning to your students. Using the school official exception, the district gives the provider student names and other information from school records other than just directory information. This allows the online school platform to set up a system that allows schools, parents, and students to see attendance and academic progress. You find out that the outside contractor is taking that information and selling it to a third party for advertisement purposes. Is this a problem? Yes, clearly a problem. They can't use that information for that purpose. It goes beyond what we would normally allow. They can only use it for the purpose that we're giving it to them for. And there are strict rules on them reproducing it. They can't reproduce it to anyone else unless they have the school district's permission to do so. So they're supposed to keep it and use it for exactly what you give it to them for. All right, the health and safety exception. There is a health and safety exception. This exception sometimes gets overused. It used to be very, very, very narrow. After the Virginia Tech school shootings, where there were some questions at the university level about whether they could have shared information with the police, they broadened it a little bit. So you're supposed to consider the totality of the circumstances. Do we need to share this information for a health and safety purpose? There has to be a significant threat. It can't be some sort of vague notion that there's a threat. Again, you can disclose it to someone for the purpose of protecting the health and safety of students or others. Based on the information available to you at the time, you have to have a rational basis for concluding that it would help to share this information. And then after the disclosure, you need to document that disclosure. You need to document what you disclosed, why you disclosed it, and who you disclosed it to, and put that in the student's records. But if you have a serious, concern, particularly a shooter situation, a real school danger situation, you can release information to the police under this exception. So what about social media? This is another area where obviously we do a whole lot more than we used to, and the questions come about the FERPA. Ms. Smith tweets the following picture of her science class with the caption, "Johnny and Mary having fun in science class." She did not have the consent of the parents to tweet this. Did she violate FERPA? Yes. And I think a lot of schools have really struggled with this, because a lot of schools really want their teachers to, have a Twitter page or whatever, Instagram, and tweet stuff out, share it with parents and all that. but it does technically violate FERPA. It would have been better had it just said students having fun in science class. Then at least the names aren't there, and we can argue that they're not necessarily personally identifiable, but they really are. So again, if you want your teachers to be able to share pictures on social media, you probably want parents to sign a permission slip and say that you're giving permission to parents to share that. And there are other good reasons for doing that too. I can't tell you how many times we've had situations where somebody shared a picture on the internet and we discovered that the parent or the child was in hiding, and a ex-parent found the child using those pictures. That actually happens a fair amount. So there are reasons why we may want, other than FERPA, that we may want to get permission to do that. Obviously, we have more concerns with confidentiality as we go through the virtual world. And here's a couple different ways where we may have concerns. Taking home records, we get this question a fair amount. Does FERPA prevent me from taking documents out of the school? And the answer is no, it doesn't. There's nothing in there that specifically says that, as long as you have a legitimate educational interest in using those documents. You can't, again, obviously you can't disclose those documents. You can't take them home and use them for an improper purpose. And you do, as a teacher and as a school, have an obligation to maintain security over those documents. And so I'm not saying it's a great idea, but it is not a per se violation of FERPA for a teacher simply to take documents home with them. So best practices for protecting privacy. You want to be as transparent as possible with parents and students regarding how you collect, share, and protect and use student data. And there are just a number of, there's some suggestions there. I won't go over all of those, trying to get us a little bit back on the schedule. So again, remember, in addition to prohibiting us from releasing information, FERPA does give parents a right of access to their documents. So FERPA says that if a parent makes a request for a document, we have to provide it to them within 45 days of receiving the request. That's actually a really long time, but that is what the law says. And this comes up a lot in the special ed world. So I know from, and I am not a special ed attorney, but I know from working with our attorneys who are, you know, when somebody takes over a case or files a due process hearing against a school district, they will frequently ask for all of these records. And that is usually treated as a request under FERPA, and they usually argue that they have 45 days to produce those documents. FERPA does not require you to produce copies. It really just requires you to produce access, unless providing access would effectively prevent the parent from viewing the records. So if you are a school district that is geographically very, very big, and you know a parent asks for documents and it's difficult for them to get to your school, you might have an obligation to then provide copies. This came up during COVID, where we didn't want parents coming up to the school. And so at that point, I think school districts were sharing a lot more, either providing copies and sending them, or figuring out some way to do it online. So unless, and it occasionally comes up with divorced parents. So you may have a parent that doesn't even live in Texas and wants a copy of the student's records. If that parent can't come in and look at them, then you might have an obligation to provide copies. So one thing to take into consideration is that this applies to all records that we as a school district maintain control and access over. So if we have taken documents and given them to a third-party provider, let's say we've done it legitimately, but we no longer have copies of those, they're all with Google or whoever, and we get a request for them, we would still, as a school district, would still have an obligation to go get those records and provide a way for them to be, the parent to have access to them. Let's sort of retreat. So here's another, so we frequently get asked about classroom observations when a parent wants to come in and observe a classroom. So here's an example. Henry, a middle schooler with autism, complains to his mother a lot about his general education teacher, Ms. Shouty. His mother grows increasingly concerned about the way Ms. Shouty is allegedly talking to her students. during virtual learning. Before addressing her concerns directly with Ms. Shouty or the principal, the mother decides to observe Henry's virtual lessons to see how Ms. Shouty is speaking to the students. The mother then sends out an email to the parents of the other special education students in Ms. Shouty's class about what she observed during the lesson. Are there any issues there? Are there any concerns with FERPA? I won't make anybody answer that. It doesn't necessarily prohibit the parent from observing the class. And we know this, the Office of Civil Rights puts out letters that are letters, sort of like letters to the educator, letters to, this was called letters to mamas. It's not mamas like mothers. This was actually to a woman named Jenny Mamas. But maybe we'll all think it's funny that it's letter to mamas. It doesn't specifically prohibit a parent from observing, but it also doesn't, FERPA doesn't give you the right to observe. So it's really silent on that issue. And that would be true for virtual classrooms as well. Now, observation would be okay as long as we are not disclosing personally identifiable information about students. So that can get really tricky. Just seeing the student in the classroom is not disclosing personally identifiable information to a parent. But if the teacher is reading out grades or something like that, that could be. So we got to be careful about that. So, and again, for that reason, this is one of the major reasons why I think a lot of school districts really try to discourage non-students, parents and other people from sitting in or observing virtual lessons, because there probably was information at times that was being revealed in those classes that might arguably be personally identifiable information under FERPA. What about recording classes? So we got this question a lot. Can a school district record classes? Does that violate this? We're doing it now. And we're doing it because maybe we have a student who can't get online, and this happened during COVID, who couldn't get online during the regular day, and they wanted to get online, in the evenings. Or I literally had a school district where the family, right before COVID shut everything down, went to Turkey, which is almost 12 hours off from here. So they didn't want to have to get on there for live lessons because that was the middle of the night there. And so they were trying to record it. Again, it's okay in the abstract to record classes and make it available to students enrolled in the class. It might be a good idea to get consent from the other students just to dot your I's and cross your T's before anything happens, that it's okay for the virtual lessons to be shared with Billy, because Billy's not here and needs those. But these are going to be considered the education records of the students. So we may have an obligation to maintain them. We may have an obligation to produce them under FERPA if a parent makes a request for them. So, and for that reason, if you are using a third-party vendor to do your online education, you want to look at that contract and figure out, are they maintaining copies? How are they maintaining copies? And if we need a copy, can we get a copy from the vendor of that? Because you might have to if the student asks for it. So again, takeaways when recording classes. Are the recordings maintained as an education record? They probably should be. And then, did they capture any personally identifiable information about the student? So this is the issue that we get the most questions about, is in student discipline situations, when can we share information with one parent about what happened with the other parent? I will tell you this, and this is going to surprise you a little bit, because normally the lawyer is the one telling you, you must follow the law. Here is the reality of FERPA. FERPA has no damages. There's another case that went to the Supreme Court where the court held that FERPA does not provide for a private cause of action for damages. So what that means is you can't be sued by a parent for money for violating FERPA. Really the only feasible remedy under FERPA is somebody can call and file a complaint with FEPCO in Washington. The FEPCO people are actually good people, and they're usually very cooperative. They call you and they say, hey, what's going on? And you have a conversation. And sometimes they say, okay, don't do that again. And sometimes you agree, maybe to do some training or stuff like that. It's not the world's worst thing that happens. So the damages for violating FERPA are actually, or the potential for damages is extremely low. The problem in not providing information sometimes is extremely high. Rhonda talked to you about Title IX in your last presentation. I do a lot of Title IX litigation. In many of my Title IX cases that are student-on-student cases, I've got the plaintiff, the parents who are suing the school district are mad because we wouldn't tell them what happened with their kid. And it's because the school district was worried about FERPA, and legitimately so. But if you have a conversation with your attorney, if you're talking to me, and we're trying to figure out the possibility that somebody's going to get mad at us for violating FERPA, versus the possibility that we're going to be sued for 3 years under Title IX because we made a parent mad because we would tell them something, I'm going to go with releasing that information and let's ride the FERPA wave out. So that said, we frequently get requests from parents in student discipline situations who want to see something frequently, the video, because there's often a security video. So let's say we have a video of 2 students fighting. Can we release that? So what FEPCO has decided, and this is just a very practical decision, is that they have decided that that is the education record of both students. And therefore, you can show it to both students and their parents. However, they want you to show it. They don't want you to give them a copy of it, because then you've got a copy of the stuff floating around of another student. But you can show it to them. So that's the simple answer. If you have a video of a fight, parent wants to come in and see it and says, can I watch it? The answer is yes, you can show it to them. That's also true of other things. If you have a statement and the statement is just about, actually wrote down the regs. This is actually, and I'm not going to read this to you, but this is actually from the FERPA regs. And basically what it says is if you have a statement about 2 students who got into a fight, and a parent wants a copy, you can give it to both parents because it's about both of their kids. Now, if there's a statement about a third kid, you know, Johnny hit, what's the example? Johnny and Michael get into a fight, but John also punched Stephen in the stomach and took his gloves. You wouldn't be able to give it. Then you've got a third parent involved. And so you may not be able, you might have to redact that. And of course we can always redact things to get certain information out, but that's the general rule. There's also something called a bystander rule. So to the extent you have a bunch of people in a video who aren't actually participating in the fight, they're just standing there watching it. If you have security videos of kids walking down the hall, and that's all they're doing, they're just walking down the hall, that's not their educational records. And again, you're not really going to see that anywhere, but FEPCO treats those people as bystanders. So it's not their educational record. That's just a convenient rule because most of the time we don't really care if there's just somebody walking down the hall or somebody standing around watching a fight. So a video of a fight would be the education record of the 2 kids doing the fighting, but not the education record of all the kids standing around. So there you go. That's FERPA in a nutshell. You do want to keep an eye on how when the new regs come out that Rhonda told you about. We've been trying to get the Department of Education to be more explicit about FERPA and when we can share more information. So if this is something you're interested in, keep an eye out for that. And otherwise, I'm going to pass the mic back. Y'all get to hear from me again later, but thank you very much.